First item on our agenda is the zoning hearing board of KRE Upper Macungie Associates, Lower Silver Lake Road. Okay, we're going to do the presentation first, Ed, and then. Yeah. Okay.
So I'll defer to Jerry about how you want us to get started. We can talk first. I know special counsel for the townships in the audience. I assume you want to introduce him and have him come forward and participate. So I'll defer to you as that.
Well, why don't you do a presentation that you prepared, assume it's not going to be overly long.
No, we'll not.
Don't do that, and then we'll ask you some questions, and then we'll write up Mr.
Okay, fine. So I'm here tonight with Joe and with Tom Comitta, who's seated between us, to advise the Planning Commission of an application that we filed earlier this spring, which is called a Substantive Validity Challenge with a Curative Amendment. That is a procedure that is identified in the Pennsylvania Municipalities Planning Code, and it's pretty unique. And the reason we did it is because of what we have identified as a deficiency in the jointure ordinance that does not presently allow for market rate apartments. Planning Commission was first introduced to this project last year. We had initially reached out to the administration last summer, made the administration aware that we had an interest in talking to the township about a different development scenario for this particular parcel along the bypass in the OR district than what was currently approved for that parcel. And what's presently approved for that parcel is a 210,000 square foot office complex with upwards of 900 parking spaces. That was approved throughout the years in the early 1990s. It was part of what was then known as the Silver Lake Executive Campus, and in large measure, the establishment of that Silver Lake Executive Campus created the needed right-of-way for the Newtown bypass to ultimately be built through a large section of what is now the bypass. So, last summer we approached the administration and said we'd like to have a conversation about this alternate development scenario. So through the summer and early fall, we had a series of meetings with staff and others to introduce everybody to the project. And at the time, I thought, and those of us that I'll introduce shortly that were with us during those conversations thought there was some interest in looking at an alternate development scheme for the site. At the same time, I know, and we all know, that the Bucks County Planning Commission was interested in encouraging municipalities and Bucks to look at other types of residential housing, including apartments, to try to make entry-level opportunities for all different strata of potential renters, buyers, etc. So it seemed like good timing that we were talking about a market rate apartment project for this site while there was other conversation going on countywide about that other potential expansion of residential use. So we appeared before this body right before Christmas last year, where we made a full presentation of what we contemplated for development of the site. And we were told by the administration that from their standpoint last fall, it wasn't the right time. They're focused on other budget issues, other litigation that was pending both behind here and over on the bypass. So nothing ever materialized since December of 2022. So as we've mentioned in the application, we thought it appropriate to try to get a conversation refocused on this particular topic. And again, not because of it, but since then, some of the other more pressing, from your standpoint, pressing matters of litigation have been resolved. Both the toll project behind us and now those on the block here. So our feeling was then, as it is now, that it's an opportune time to continue a conversation about what we introduced to you guys last December. So a little bit further background and the reason we're here. Tom Comitta, to my right, is going to talk a little bit about the substantive validity challenge procedure in the MPC. Not very long, but just highlight what it is, because contrary to what it has become, it doesn't have to be a cudgel or weaponized. We're trying to foster a conversation because what we believe, based on what we've done, is there is a problem with the ordinance. Going back, as I think most people know, the jointure ordinance was created in 1984. And at the time it included Upper Makefield, Wrightstown, Newtown Township, and Newtown Borough. Ultimately, Newtown Borough dropped out. So for many years it's been the 3 townships involved. When it was created, the jointure ordinance contemplated a B11 mid-rise apartment use. By definition back then, what that was a minimum of a 3-story freestanding building, 3 stories but no more than 6, and greater than 16 number of apartments. That is in direct contrast to a garden-style apartment use, which remains today. From 1984 until 2005, that B11 use was in your ordinance. But in 2005, the jointure amended the ordinance to delete it, and it's never been replaced with anything in the last 20 years, almost 20 years. So for the first 20-some years of the jointure's existence, it was there, and then for the last 19 years, it hasn't been. We think that's a problem. We think it's been a problem from the very beginning because the way that the appellate decisions have come down on this, every municipality is supposed to have a standalone apartment use provided. And at no time, since 1984, even when it existed, was the B11 use a standalone. You were only allowed to do it as part of a performance subdivision in an R2 medium density district. So you never could do it back then, can't do it now, and no one's ever done it since 1984, even before. No one has ever done it. So that's a problem. And our view is that we're here to try to address what I hope everyone at some point will recognize is a problem, and work cooperatively to try to figure out a solution to it. And it happens, even though that's not the focus of tonight, the site that we introduced to you guys and to the administration last summer and fall is a site that I think is ideally suited in terms of its location for a use like this. It's at the edge of the township, closest to the bypass and other arterial roadways, and it seems at the end of the day that it would really make good sense if we would all sit down and try to look at something objectively, because we think if you do, you're going to realize that there's an issue with the ordinance, and we think we've identified a really appropriate solution to solve that issue. So I think that's the background of where we're at. Tom is going to talk very briefly about the substantive validity challenge language in the ordinance. Tom is a longtime planner who's very familiar, as we are, with the MPC, and then Joe's going to follow up and talk about some more recent developments, of which he's personally aware, and it's reflected in our petition. I mean, nothing we're going to talk about you guys haven't seen in the petition. So, Tom, if you would to
Sure. Thanks. Excuse me. Hi, my name is Tom Comitta. I'm a town planner and landscape architect from Westchester, Pennsylvania. Next month, July of 2023, will be my 50th year of working as a planner in Pennsylvania. And our firm, Thomas Comitta Associates, has represented about 130 municipalities during this period of time. Currently, we're the municipal planning consultant to 26 municipalities in Pennsylvania. And I was invited to be part of the team to look at all the points that I had just summarized and that Joe will talk about. And I just wanted to share with you in the beginning of my career, in 1973, there were a number of substantive validity challenges and associated curative amendments that were filed in the municipalities where I was representing them as a planner. And so on first blush, I would ask the first night, like, well, what is a curative amendment? And why did the legislature call it that? And simply, it was to cure a potential defect in the ordinance. And when first introduced in the municipality's planning code, the legislature thought it would be a useful tool as an administrative remedy for a property owner to have this conversation. And so, just very briefly, I want to mention, if you know this all inside out, I'll do really quickly, but in the municipality's planning code, in what's called section 609.1, procedure for landowner curative amendments, it says, the governing body, in this case, the Board of Supervisors of Newtown Township, if they determine that the challenge has merit, they may either accept the curative amendment, which accompanied, so there was a text amendment that accompanied the challenge, and it pertains to the OR district, as you know, in the southeast corner of Newtown Township, may accept the curative amendment with or without revision, or may adopt an alternative amendment. And so, coming up in July 12th and 17th, we'll be back in this room in front of the supervisors, and we'll see how that works. But in my collective experience, I've had maybe 30 curative amendment cases, and I consider myself a resource. In my career, I've written probably over 50 zoning ordinances and reviewed another 150. So I'm very familiar with those kinds of items. But as Ed pointed out, the original intent was that the curative amendment process was not meant to be adversarial. But in my 50-year career, almost every time a curative amendment is filed, it causes a question, well, what is a curative amendment? Where do these words come from? What's the cure? What is the idea in mind? So eventually, I hope I can be a resource for a win-win solution. And I have an incredible amount of experience that I am willing to share. And take it away, Joe.
Thanks. Joe Blackburn from Wisler Pearlstine. I think Tom's commentary about the history of the Curative Amendment is insightful, and I'd ask you to hopefully keep that in mind as we move forward. But the additional layer that I'd like to add is really trying to put a point on what it is exactly that both this commission and ultimately the Board of Supervisors is being asked to opine upon in your instance and determine in the instance of the Board of Supervisors, because that, much like the process itself, is probably foreign, or at least somewhat unfamiliar. And I think that conversation necessarily starts with what we are not here to talk about tonight. And what we are not here to talk about includes the illustrative plan that was submitted with our application. We don't even have an easel. We don't have a copy of the plan because the plan and the merits of the plan are not at issue. The advisability or the desirability of development on the bypass or in the township generally is not the topic of conversation for this application. Traffic, desired for preservation, historical significance, open space, not the subject of this application. A perception or a desire to be perceived as tough on development is not the subject of this application. A desire to, quote, uphold the letter of the law, not the subject of this application. And I would hope it goes without saying, but it probably doesn't. Hyperbolic commentaries such as, zoning Armageddons or the like are not the subject of this conversation. What is the subject of this application, the sole issue before you tonight and ultimately before the Board of Supervisors, is whether or not the joint municipal zoning ordinance, as it is presently constituted today, provides for the B11 mid-rise apartment use. That is it. And candidly, you've already made that decision, repeatedly. This very commission, in the context of the next agenda item, the OLI and LI district, has repeatedly in a public forum, which I've been at myself, acknowledged that as a part of that overlay effort, one of the issues that the township desires to address is including or providing for a multifamily apartment use, because it does not currently exist in the ordinance. And you've gone as far as to say and acknowledge that this leaves the ordinance subject to challenge. So without rhetoric or, commentary about that, I don't know what else we really need to say on that topic, because this very commission and the Board of Supervisors, in the context of that, has already determined that issue. Notwithstanding that determination, the Board of Supervisors has chosen to participate in that adversarial manner. So we're here tonight, ultimately before the Board of Supervisors. And candidly, we've racked our brains as to what the possible grounds that we can sit here and say, or the township will ultimately sit here and say, going through its separate counsel, that the ordinance is not deficient. You've heard the commentary, you've heard the background, you've heard that the use did exist, you've heard that it was revoked, and you're trying to cure it yourself. So we're kind of, at least I am at a loss as to what that commentary is going to be. I don't know if we're going to hear it from Mr. Bagley tonight. But the harkening back to something that Mr. Comitta said, the opportunity for collaboration exists. And that has been, I think, expressed when we were before you in December, and remains the hope and intent of the applicant in this instance, the opportunity for collaboration. But if we're going to fist fight before we even get out of the starting block on issues that this commission and the Board of Supervisors have already acknowledged, that opportunity doesn't ceases to exist. So, and I'm probably naive for asking, and Ed has told me that I'm naive for asking, but the hope and expectation as a result of tonight is that this commission will reiterate that which it has already concluded, which is that the ordinance is deficient with respect to this use, and make a recommendation to the Board of Supervisors that we don't fight about that threshold issue and we get right to the collaboration. Because if we don't, then there isn't a collaboration. So I think that in some substance is three musketeers here have to offer. I'm sure Ed, Mr. Comitta, and myself can answer any questions that the commission or professionals may have.
I appreciate it.
First of all, there won't be no fist fighting here tonight.
I'm glad. I agree.
We appreciate your sense of desiring collaboration, but once the challenge is filed, we have time limits and legal requirements. And to preserve our position on things, you have to take an opposing position. Whether there is subsequent grounds for collaboration remains to be seen. But the supervisors, in their wisdom, have decided to, at this point at least, take an opposing position, and we are the instrument of that body, and we cannot entertain other concepts at this point unless permitted by the supervisor. So we're not in a position where we can say, yeah, we like the idea. It's not going to happen, just so you know that. But there have been discussions about apartments, but in fact, the idea about rezoning and doing an overlay district of business companies intentionally excluded this parcel. We didn't include that side of the bypass. And again, there was a good reason for that. We didn't know what we wanted to do with that parcel at the time, but we knew that we had to do something about the business commons. And perhaps that should include it. We have not finished any of our plans yet. We're still working on those. The supervisors have not approved anything either. So whether or not that overlay district includes apartments, well, it may happen, and probably will happen. We can't be sure it will, and it's certainly not going to include this parcel. And that's where that stands. So I invite any of the other members of the planning commission to ask their questions or make their statements as they wish. But our position is that the supervisors have spoken, and that's where it stands until we see further direction from the board of supervisors.
Fair enough.
Any of the members want any comments?
If I can find it, it's here. Thank you. Yes, Madam Chairman, I have some comments. Mr. Blackburn is associating that traffic is out of bounds, strikes me as unreasonable. I mean, we are the planning commission, we have to look at all these elements. You introduced, your group introduced the KRE study that was included in the Wawa proposal. And so that raises some issues for me. Currently, according to TPD, this is weekday AM peak hour traffic is 100 vehicles on Silver Lake Road. According to the TPD projection, Wawa is going to generate 121 new trips. What that means effectively is you have a peak of about 221 trips, an increase of 121%. That's before you guys add 87. When you add 87 to that, then we have 303 weekday AM trips, and that increases the current level by 208%. You're multiplying it by more than 3. You have the same problem with the PM traffic. If it was 149 pre-Wawa, projection after Wawas, it goes to 242. That's a multiplication factor of 1.6. You're suggesting that you'll add 88 new trips. That multiplies the level by, it's a 121% increase, and it multiplies the current level by 2. That's an awful lot of traffic, particularly when you keep in mind that there's no provision for widening that road. It's referenced in there in the TPD study, but it's not, that intersection does not appear anywhere on the 10.12-year calendar, and it does not appear on the Delaware Valley Regional Planning Commission traffic improvement program, transportation improvement program. That's an awful lot. And then you also referenced in that is the level of service on the traffic signs. Right now, it appears from the TPD study that you guys cite that the level of service on that road is going to drop to E or F as early as this year. That's before Newtown. That's before Wawa, and certainly before you. It's hard for me to see how we can justify throwing this kind of traffic quagmire in the face of our residents. There's another issue, and I would like to address this to an engineer. The original TPD study.
Yeah, can we maybe address that first, and then, I don't know. There has been some confusion about the traffic study that was submitted. We did not submit the traffic study that was submitted with Wawa. Our traffic study is a part of our application, dated, I don't know if it's May, whatever. It's in our application. It was not the Wawa traffic study. And I appreciate your attention to traffic and desire to talk about traffic, but it remains the case that that is not the subject of this application. That's not to say that it won't be. It will ultimately be the subject of, we might as well be talking about stormwater tonight, where they are not the subject of consideration for tonight for this application, which is exclusively with respect to whether or not the ordinance as it presently constitutes permits the B11 apartment use. Again, that is not to say that there will not ultimately be a day for traffic. It is not today.
Okay, before we go any further with questions and comments from the planning commission, I want to introduce Mr. Bagley, who has been retained by the township.
Should I go to the podium?
Sure.
Put it on.
Good evening. My name is Joseph Bagley. It's a strange coincidence, but I was a associate and partner in Wisler Pearlstine for 33 years. It's like old home week here tonight. I'm not going to turn this into an oral argument. It's not the appropriate forum for that. I'd just like to say a couple of things. One, this curative amendment process is a very, it's odd to people who are lay people who are not used to it. It comes up occasionally. One of the things that the municipality planning code provides for curative amendment proceedings is that an independent attorney can be appointed by the township to defend the ordinance, and that's what my role is. I've been appointed to defend the ordinance, and at the hearings in front of the Board of Supervisors, I will defend the ordinance vigorously. One of the things I heard this evening was, and it's in the curative amendment challenge, that standalone apartments are not provided for, and as a result, the ordinance is invalid, and that it is only permitted as part of a performance subdivision. I disagree with that statement. I believe that the ordinance is valid, even though it provides for garden apartments only as a part of a performance subdivision. There's nothing inconsistent about that. There's nothing invalid about that. There's a case, you're probably familiar with a developer named Bruce Goodman. Bruce Goodman filed a curative amendment challenge in Lower Gwinnett Township a number of years ago, and that case went to the Commonwealth Court. His position at that time was that Lower Gwinnett only provided for mom and pop commercial retail, small retail uses, and Mr. Goodman wanted to provide for big box retail. He wanted to provide for Walmarts and Lowe's and Home Depots. It went to a vigorous defense for a number of years, and eventually the Commonwealth Court agreed with Lower Gwinnett Township and said, you don't have to provide for big box retail. You don't have to provide what you think the market is open to right now. If you notice, this curative amendment challenge says you provide for garden apartments, you don't provide for mid-rise apartment buildings. You have to provide for mid-rise apartment buildings. Much like the Lower Gwinnett case, the Commonwealth Court has already said you don't have to provide for big box retail. Mom and pop shops are adequate. Now, I'm not comparing garden apartments to mom and pop shops, but garden apartments are a form of multifamily residential use that are permitted in the township. There's other forms of multifamily residential use permitted in the township. And when you look at the municipality's planning code and what it provides that zoning ordinances must provide, it doesn't say apartments. It certainly doesn't say mid-rise apartments. It says a reasonable range of multifamily uses. That's exactly what it says. And that's exactly what Newtown provides. And I think that's exactly what the Board of Supervisors are going to find that it provides. So with that, I'd just like to say that there's going to be, I think the phrase is, keep your gunpowder dry. I'm going to keep my powder dry for the hearings when there's sworn-in witnesses and there's evidence being taken. But that would be a flavor for what the defense of the ordinance is going to be. Thank you very much. Madam Chair, I do have one item of clarification. They did in fact have their own traffic study, but TPD employed the same figures that they used with historical figures they used with Wawa. So that's where there's there. And I regret the confusion.
Thank you. Yeah, does anyone have any questions for Mr. Blackburn?
I was just going to Does our current zoning ordinance have any prohibition against apartment units? Does it define, like a prohibition against apartments, does it define it that way? It defines dwelling units or multifamily?
I didn't hear the beginning part of your question. Did you say the zoning ordinance?
Yeah, our current ordinances, is there a specific line in there that's a prohibition that states against apartments as a definition?
No, it doesn't.
Yeah, I didn't think so. Thanks.
I have a couple questions. In 1984, the use was in the jointure. It was removed in 2005 because the jointure partners agreed that the jointure did provide adequate housing, different types of housing throughout the jointure, and removed it from the jointure for that reason. When KRE first came in with their plan, all of their paperwork stated garden apartments, even though they're not proposing garden apartments. That was kind of confusing to me. Why did they come in with all their paperwork saying garden apartments? And during the meeting, no, they're not garden apartments, but everything was in writing as garden apartments, everything on the paperwork. The current ordinance provides for 9 different types of housing for residential uses, village housing, single family, twins, and we do, apartments are permitted into the jointure. We have Newtown Place down off of Sycamore Street, which is 150 units. It was built in 1987 and provides 1, 2, 3 bedroom apartments. Is that sufficient in our jointure? I mean, we are providing, our apartments are in our...
I would maintain it does, because as I think I said originally, that the NPC only requires a reasonable range of multifamily uses.
Which we have.
It does not say you must provide mid-rise apartment buildings. If you notice, the challenge says you don't provide for apartments as a standalone use, you don't provide for apartments, and then it goes on to say, and our cure is mid-rise apartment buildings, not any other type of apartment, but mid-rise apartment buildings. So I think what they're staying away from is that the township only needs to provide a reasonable range of multifamily uses, not mid-rise apartment buildings.
Which we currently do, correct?
Correct. That's what I believe that the evidence is going to show when we get to the hearing for the Board of Supervisors.
I mean, this may not be legal, but it just seems to me, in my vision of Newtown, 3 to 6 story apartment buildings does not fit this town. Just my opinion.
And also nothing that, it doesn't have anything to do with the Curative Amendment, but something of this density, people have to understand the effect on the school district, on the infrastructure of the township. If you want to build as zoned, as permitted.
Well, it's less dense. I'll respond. It's less dense than what you talked about the last time with the overlay, which you talked about 24 units per acre. We're far shy of 24 per acre, which is what you talked about with the bus
And you're
stand.
currently proposing 245.
It is less dense than what you talked about last time with the bus stand.
So those were discussed, nothing was decided.
So, Joe, in all honesty, you've been before us for a long time gone through this. I do take a bit of offense and say that when you came to the board and heard us as we go through the changes that are happening in zoning code and zoning overlays, calling the code and what we have deficient. I don't think anyone on this board actually said it was deficient or believed it's deficient. I think that we're looking at how the world has changed, both in building technologies, uses, EV cars, and how things have developed, especially after a time that we've all suffered through COVID, where you see your township growing a lot more, people are moving out of cities. So I personally, I don't believe anyone on this board said that that code was deficient. So for you to use it in that regard and then say that you sat there and said that we said it was deficient, I personally take offense to that, sir.
Any other comments? Yes, yeah, I want, anybody come, public comment, John? You want your supervisor, like, come on up.
John Mack, supervisor, you mentioned that we can adopt an alternative amendment. You submitted something that was very specific as to what you want. Can you define what a mid-rise apartment building is? You mentioned mid-rise apartments very often, and that's the basis of your challenge, I believe.
It's not. It was candidly out of familiarity.
Okay, so if we came up with an amendment, a B11 use, that only had 2 stories, say above a commercial zone, this is in fact what the Bucks County Planning Commission is proposing for the OLI district. It's not a 3-story apartment buildings. It's what's called mixed use, which has commercial use on the bottom floor and maybe 2 floors above it. Now, that could be defined as a multi-unit apartment in the B11, and that could be up to us. I mean, you submitted a B11 ordinance that was totally laughable because it included dog grooming. I don't know how that got in there, but you know, you had all these specific things that you want, which is not really necessary for an apartment use.
Well, that's your view. Our view
That's
is
right.
that
And
you're doing nothing.
hold on.
We're doing
Don't
something.
interrupt me, please. You mentioned there were 3 ways we could react to this, and one of those was to adopt an alternative amendment. That's your words. So,
Except you actually don't have that opportunity.
you don't have that
You
opportunity?
don't have that opportunity.
Why not?
Because the MPC allows the township to do that one time in a 3-year period. And you already shot your shot.
What are you talking about?
It's right in the application. It's very clear. We tried to make it as clear as possible. The MPC allows the township to adopt a self-cure one time in a 3-year period. And you have already done that. So you're
when did we do that?
for the E30 use.
With the E30?
Yeah. You already participated. You adopted a
So
self-cure.
why-
Hold on, I'm not going to interrupt, please. You adopted a self-cure. So yes, the MPC does provide that as the 3.
All right.
We thought maybe someone would read the application and understand why that is not an opportunity here.
This is why I called it the zoning on the head.
I caught that.
So, thank you very much.
Now, another thing that you mentioned in your filing was that the failure to provide for apartments anywhere within the township must be viewed as a legal equivalent of an explicit total prohibition of apartment houses under the zoning ordinance. We have apartments.
But you can't provide for them by variance. And first of all, I didn't provide that. That's the Supreme Court of Pennsylvania. That language that you just said is in Regosh, which is the applicable case law. That's not my language. That's the Supreme Court of Pennsylvania. And it specifies you can't cure this deficiency by granting variance after variance. You could have a township full of apartments. If they're all by variance, your ordinance is still deficient.
Well,
That is a legal law. I mean, I
understand.
Yeah, I understand. Just to respond to that.
Any other members have any comments? Any more public comment? Anyone want to make any comments? No?
Okay, see you on the 12th.
Thank you.